Well, hey, everybody. I think we'll give everybody just until 6:30 to log on, just to make sure that we've got everybody. It was just a tad bit early. Okay, I can't see if there are participants joining or not, but I think we can go ahead and get started. So welcome, everybody. Thanks for tuning in tonight. I think we have a really interesting program ahead of us for the Citizens Law School, so thanks for joining. Tonight our topic is the federal judiciary, and so who better to present on our federal judiciary than one of our federal judges here in Montana. So Judge Katie DeSoto has really graciously agreed to talk to us tonight about her job and the role that she plays in the bigger picture of the federal judiciary. And so just as a way, a little bit of ground rules, I do want to open it up to Judge DeSoto, but we welcome questions from anyone and everyone, with the caveat that Judge DeSoto will not be talking about cases, specifically in front of her. She has to be careful about that. But we would welcome questions, especially because this is an opportunity that we probably don't have a ton to ask questions of a federal judge. And so if we want to get started, Judge DeSoto, so you are a magistrate judge, and that's kind of a funny word. At least for me, it makes me think of lawyers wearing powdered wigs and dark robes in the courts of England. So maybe you could start off by telling us what is a magistrate judge and how you got to that position.
Sure. Well, first of all, thank you for inviting me to participate in this. I am very much looking forward to it, and I think it's a wonderful service that the State Bar provides to Montana folks. And so thank you for inviting me. More than happy to be here. So a magistrate judge in the federal system is, well, there are two main judges that we have in the federal system on just the district court side, and they are district court judges, who we sometimes shorthand refer to as Article 3 judges, and then magistrate judges. And we are Article 1 judges. And the articles that I'm talking about are the articles of the United States Constitution. So Article 3 judges, district court judges, are nominated by the president, they are confirmed by the Senate, and they serve for life. So an example of an Article 3 judge, for example, is a district court judge in Montana, a Ninth Circuit appellate judge, the United States Supreme Court. All those folks are lifetime appointments. A magistrate judge and a bankruptcy judge, we're both Article 1 judges, are judges that are created by statute. So Article 1 of the United States Constitution provides Congress the authority to appoint judges, or to create judgeships, I should say. And so they created the bankruptcy court system, and they also created magistrate judges. The functional difference is, and over the years, the magistrate judge position has expanded. When it was first enacted, I think in the late 60s, early 70s, mostly handled discovery issues. Then it expanded to sort of do some mediations or negotiations. But there was a catch-all and other, I can't remember exactly what the phrase was, something like, and other duties as assigned. And in some jurisdictions, that was very broad, like, hey, you do all the work. And in other jurisdictions, it was very narrowly interpreted, and the magistrate judges weren't highly utilized. And so then that changed, and Congress introduced the concept of consent. And what consent means is that the parties can consent in civil matters to have a magistrate judge handle an entire case soup to nuts. So if the parties do that, the district court judge is divested of jurisdiction in that case, and that case would become the magistrate judge's case alone. And so different districts do it differently. The way we handle that in Montana, and this is a relatively new change, but the way we handle it now in Montana is that all incoming civil cases are assigned automatically to a magistrate judge. There are certain types of cases that we cannot handle, cases involving elections. Those will never be assigned to a magistrate judge. But other than that, all incoming cases will be assigned to a magistrate judge. then the parties are given notice of that assignment, and they can opt out. We used to be an opt-in, and now we are an opt-out, which means there is presumed consent unless you affirmatively say, no, thank you, I would like to go to the Article 3 judge. So what that means, and this is a great thing for the magistrate judge program in Montana, is that we have a pretty high consent rate, which means parties often agree to us. So that just means we have a lot of different interesting types of cases that we get to preside over. And so it's I think expanded our workload in a very positive way. And that's all on the civil side. On the criminal side, a difference between a magistrate judge and an Article 3 judge is that magistrate judges, even if the parties wanted to consent, magistrate judges cannot preside over federal felony sentencings. So as a magistrate judge, I do all of the initial criminal proceedings. So when somebody comes in, I do the initial appearance, I do the arraignment. If there's a detention hearing, I hold the detention hearing. If there's a preliminary hearing in cases that are not by way of indictment, I preside over that as well. I can also do changes of plea if the parties consent to that, and then which happens all the time. And so then I would conduct the change of plea hearing, and then the what I would do is issue what I call, well, what we call a findings and recommendation that indicate to the judge, all right, I've gone through the plea hearing. I think it's a knowing and voluntary plea. I recommend that you accept his change of plea. And then the judge reviews that and goes from there. So those are just sort of some differences in terms of an Article 3 judge or district court judge and a magistrate judge. But one thing that I think would be helpful, and this is going to test my technological abilities, but I do have some slides that sort of break down the federal judiciary, how we're organized, how we're different from most state court or organizational ladders or chains. And I think it might be helpful if we start with that to kind of understand what types of cases come before us. And before I do that, I do just also want to echo what Anna said in the beginning. If you have any questions either about the particular topic that I'm talking about at that moment, or just something that you wanted to ask and had in your mind to ask, please feel free to submit those. As Anna said, I am not able to talk about any cases that are before me or might come before me. So we really, have to speak in generalities, but I'm more than happy to answer questions. And I think it would probably be a lot more interesting for everybody if this was more of a dialogue and less of a lecture. So, so feel free. All right, now I'm going to try to share my screen.
And just as a reminder to folks that if you do have a question for the judge, please put them in the chat or the Q&A function. And even if she's kind of in the middle of something, I'll be trying to monitor it. So we hopefully will get to everybody's question, but feel free to put them in there.
All right, this is just a map that breaks down the federal courts of appeals and the district courts. So in the federal system, we're broken down into circuits, which are regions, and then we have districts, which for a state like Montana, the District of Montana is the entire state. When you have more populous states, so for example, you look at even Washington, there's Western, Washington, we call it Washington Western, Washington Eastern. California has Eastern, Northern, Central, Southern. You can see, the more populous, larger states have more districts. Montana geographically is very large, but population-wise is not so large. So we are just the one district. There are 12 districts, circuits. And so you can see they're numbered. We're in the 9th circuit here on the west, and you can just work your way back. Then the additional circuits, you see the 11th circuit is the last numerical circuit, but the DC circuit is because the District of Columbia is a federal enclave, the DC circuit is really both the federal court and the appellate court for the District of Columbia. And then the federal circuit is sort of a different type of circuit. The federal circuit is a circuit that only hears certain types of cases, certain cases involving money judgments with the government. It's a it's a specialized circuit, but it is nonetheless a separate circuit. And so those and Puerto Rico, you can see there, is within the First Circuit, but Puerto Rico is also a district. So that's sort of the breakdown of how we are organized. Within, let me go to the next slide. This is just sort of a little flow chart that kind of sets it out. And this is sort of, especially on the state side, this is very generalized. But so here you see there are 94 different districts in the United States District Courts, Courts of Appeal for the federal circuit, like I said, special jurisdiction, the 12 circuits that are the appellate, the 11 in the DC. We are one unified federal court system, and the United States Supreme Court is over us. On the other side, and sometimes, cases can go from the state system to the United States Supreme Court, but this is a completely separate court system. And the state courts generally are organized. There's 51 states, so the 50 states plus the District of Columbia. The states have Supreme Courts. Many states, not Montana, but many states have intermediate state appellate courts. And then there are state district courts. So when you go down to the courthouse, like if you're saying you're Missoula and you go down to the courthouse on Broadway, that's the state district courthouse. And even though we call it the Missoula County Courthouse, for example, it's actually a state district court, and that's how that works. Montana, and I believe most other states, if not all other states, also have what we call courts of limited jurisdiction or lower jurisdiction, and those tend to be like municipal courts, city courts, justice of the peace, things like that. And there are different limits on their jurisdiction, and that's going to differ state by state. Every state's just a little bit different, but that's how that works. So that's sort of a flow chart of the organization. You can see we're separated here. These do not overlap. So if you are in federal court, the federal court has jurisdiction to hear that particular case. This next slide sets out in general, and these are sort of simplified, but the types of cases that we can handle in federal court versus state court. So you can see up at the top, it says limited jurisdiction. And what that means is you don't just get to automatically file a lawsuit in federal court. You have to have a reason to be there. And that's what we call that is jurisdiction. In other words, does the federal court have jurisdiction or an ability to hear your case? So if you look on the criminal side over here on the left, offenses related to interstate or foreign commerce, that is very broad. So for example, a couple of the main types of cases that we handle on the criminal side in federal court are drug related or gun related. So if you are involved in a drug conspiracy, conspiracy to distribute dangerous drugs, possession with intent to distribute, manufacturing, things like that. And so people often would say, well, how can a drug case be federal? But drugs travel in interstate commerce. The drug trade is under the law a part of interstate commerce. So we do have jurisdiction to that or for that. Same with firearms, it tends to be prohibited person in possession, which means somebody has lost their Second Amendment right. And they have not had that restored, and they are found later to be in possession of either a firearm or ammunition. That's a federal crime. And then you have, white collar crime. So wire fraud, tax fraud, Social Security fraud, things like that. All of those types of cases implicate interstate commerce. Foreign commerce, we don't tend to see too much in Montana, and that's just, I just haven't seen it that much. Not saying that it doesn't happen. Another
Would you,
large,
I guess, sorry, quick question
Oh.
for you. Do you think you would see more foreign commerce sort of like crime related activities if you were in a, because say like Seattle, they're also in the Ninth Circuit, but they're a port city. They're a big port city.
I would suspect so.
Probably.
Yeah. Yeah, I would suspect, I mean, not that obviously we share a border with Canada, so it's not, impossible. But my guess is that, and I actually handled a case when I was in private practice that involved counterfeit cancer medications. And that was an international conspiracy. So even though it was charged here and handled here, it obviously affected both interstate and foreign commerce because it had domestic players as well as international players. And so I suspect that might be an issue. One thing I didn't do, and maybe I should have at the beginning, is just sort of explain my background. I guess, and when I talked about becoming a federal judge, I didn't say what I had done before that. So I'm from Missoula. I grew up here and went to law school here. I clerked for a federal judge down in Billings for a couple of years, and then moved back home. And I worked in private practice for, well, clerking 2 years and 18 years in private practice before I got on the bench. But when I was in private practice, I did both civil and criminal work, but only federal criminal. I didn't do any state criminal matters. And so I was on what is called the CJA panel, and that stands for Criminal Justice Act panel. And what that is lawyers, private lawyers, who are basically a panel of federal public defenders. We have federal defenders who are the public defenders, the official public defenders for federal criminal cases, but obviously, we have 2 of them in Missoula. We need more than that. And so I was on the panel, and so I handled these types of federal criminal cases for 17 years before I got on the bench. And then the other main part of my practice was civil defense work. So I did a lot of insurance work, school, municipal liability, defended sheriff's departments, school districts, things like that, and then just commercial litigation. So I was a fairly general practitioner before I got on the bench. But so some of the things I might say come from, my experience on the bench, but a lot of it's probably going to come from my experience as a lawyer, because I was a lawyer a lot longer than I've been a judge. So that might explain some of that. The second major jurisdiction that we have in Montana, or in any state or district that has Native American Indian reservations, is we have major crime jurisdiction on Indian country, which is basically Indian reservations. And in Montana, all of the reservations except for the Salish and Kootenai are participants in that. The Salish and Kootenai reservation, Flathead Reservation, is not. And so right now there is not federal jurisdiction on major crimes that occur on that reservation. That's handled by the state. But the other reservations are within the jurisdiction of the federal government or the federal courts. And so what that means is things that fall under the Major Crimes Act, and those tend, murder, assault, sexual assault. I'm trying to think of the other ones. I believe there are 7 that fall under the Major Crimes Act. The federal government does have jurisdiction. It is discretionary, so the tribal courts have the ability to prosecute those as well, and then the U.S. attorney can decide whether to prosecute those under the federal law as well. And then finally, offenses against national security or federal property. So we have jurisdiction if somebody, well, there can be felonies. So if somebody vandalizes a piece of federal property and it's a significant loss. I actually have a lot of experience with offenses against federal property or on federal property, because one of the things that the magistrate judge does as well is handle Class B misdemeanors on federal property. And so what that means is if you get a ticket for, let's say you're in Glacier and you get a ticket for speeding, or you get a ticket for leaving food out in a bear aware territory, and you didn't, properly secure your food, or you leave trash out at your campsite or something like that, and you get a ticket for that, those are handled by the federal magistrate judges as well. So those are kind of an overview. That is an overview of the criminal jurisdiction that we have. Civil jurisdiction is a different animal, and civil jurisdiction, again, it's limited. The first type of civil jurisdiction that we have is federal questions. And what that really means is a federal statute or a matter that is of federal importance. So one of the primary types of cases that we handle under that jurisdictional avenue is civil rights cases. So if somebody believes that a person, and this is a term of art, but acting under the color of state law, it tends to be law enforcement or a state employee, a teacher, a coach, something like that. If they believe that person has violated their civil rights, that arises under 42 United States Code, Section 1983. And we just shorthand refer to those as 1983 cases. That's an example of a federal question case. If you are bringing a case that originates under or is based on a federal statute, you can bring that in federal court. If the United States government is a party, you get to, in fact, you have to sue them in federal court. The next one's a little tricky. We refer to this as diversity jurisdiction, but what it is disputes between citizens of different states. So one of the parties has to be from a state, not where the court is. And there's a minimum amount in controversy required. The minimum amount is $75,000. So if somebody has, let's say you are involved in a car accident and you are, you're from Idaho and, well, or let's say you're from Montana and you're driving in Idaho and you get in an accident in Idaho and then you come back and your insurance company is not handling the case the way you would like it to be handled. But you need to sue the person from Idaho. Or let's say their insurance company is not handling it the way you want it to be handled. You have diversity of citizenship, right? Because one person's not from here. But you also have to show that the amount in controversy, so the amount that you're going to be seeking is $75,000 or more. If it is, then you have federal jurisdiction under diversity jurisdiction. If you don't, so if there's not diversity of the citizens or the amount is less than 75,000, then you cannot bring that case. So that automatically screens out a lot of cases that we don't, that we, just won't see. And then of course, bankruptcy. Bankruptcy is a separate division. In Montana, we actually are a unified court. In most districts, they are completely separate. But only bankruptcy judges have the jurisdiction to hear bankruptcy cases. So if a person is going to declare bankruptcy, that will automatically be within federal court. So those are the types of cases that we hear on the civil and criminal side. State courts, by comparison, are general jurisdiction. So criminal, we'll just run through these offenses under the state criminal code. One thing to know, and this came up a lot when I was defending folks in federal court, you can be charged in both the state court and the federal court for the same conduct because we are separate sovereigns. And what that means is that you can be, let's say you get pulled over and they have a valid search. So I'm not trying to say anything about the search or anything like that, but let's say they find a pound of drugs on you. You can get charged in the state, and you often would first get charged in the state, and then the federal government can choose to also charge you. That's not, everybody thinks that's double jeopardy. It's not double jeopardy. You can be charged in both the state system and the federal system. From a practical matter, what I found happened often when I was in practice is that once somebody was charged federally, the state would often drop its charges because our penalty system is very significant, and the state often believed that would just take care of it. Not always, and can't guarantee it, but that would often happen. So in the state system, obviously, anything that is within the state criminal code can be charged all the way, something very minor, all the way up to murder, obviously. Civil is unlimited jurisdiction. So the civil courts take everything. And you can see state civil matters not handled in federal court. We never do probate and we never do family law. We can do tort law, contract law, and property law, but going back to that diversity, it has to be a situation where the parties are diverse. So that, I know that's a lot, and I'm kind of cruising through this pretty quickly, but those are just sort of basic breakdowns of the types of cases that we hear and the difference between state jurisdiction and federal jurisdiction. Does anybody have any questions?
I don't see any questions so far, but is like kind of maybe a good summary of state jurisdiction versus federal jurisdiction is that state courts are kind of, you have general jurisdiction and limited jurisdiction up there, but state courts are generally going to be the kind of the general default, especially for civil stuff, and probably much in higher numbers that you see just in these cases that are filed both for civil and for criminal.
Yeah, I think the next slide actually addresses that. Yeah. So this is dated, and this is only from 40 states reporting, but 53 million cases were filed in 2021 in state court. That is, and that's only 40 states, right? So we're missing 10. That's a lot of cases. And you can see, I mean, traffic and parking, 25 million, those seem small, but the court has to handle them. Domestic relations, 3.7 million, criminal, 13 million, general civil, 12 million. That's a lot.
Just as
We
a
don't do
quick,
any. Oh, go ahead.
just
No,
as
go
a
ahead.
quick reference, but what would you describe as domestic relations?
So I think what that would encompass would be dissolutions and child custody types of cases. I mean, depending on how states track their stats, I think that could be very broad or not broad. But I look at domestic relations and think that that would incorporate or include basic dissolutions, divorces, a subsequent custody challenge, amending a parent plan, something like that. I think it would be any of those. I don't know if that includes, I think DN, dependency and neglect, would most likely be reported under criminal if they categorize them the way Montana does, because even though those are intimately intertwined with domestic relations, it's actually, I think, tracked as and opened as a criminal case.
And the dependency neglect ones that you're talking about, those are when CPS gets involved with
Yes.
parents and
Yeah.
kids, right?
Yeah. And so the only time federal courts really have juvenile types of cases are when you have Indian country cases, because we do have jurisdiction over those. So obviously that number is very, comparatively very small. So here are the stats from 2022 for the federal filings. So if you just go back, I mean, just looking at the numbers, you can see how being a court of limited jurisdiction significantly limits the number of cases that you have, just because almost all are going to be screened out before they even get to us. 677 federal district judgeships, 406 cases filed per judge annually. So it's just really different in terms of the number of cases and the types of cases that we have. These are some statistics from the Federal Courts of Appeal. And again, this is from 2022.
Judge, we do have a question to ask.
Okay.
Can you go into further detail on being able to charge at both the state level and federally? And maybe give some examples. Just confused on the drug-related charges. Does it depend on the amount seized, et cetera?
Sure. So, and this might be a good time to, and maybe I don't think I have another slide, so maybe I will end the slideshow. Okay. And I can give you examples from for example, not from cases that I have in front of me now, but cases that I handled when I was an attorney. So oftentimes what happens is when folks are found to be in possession of drugs, they get charged by the state right away. Because let's say somebody gets pulled over, or, let's say there's an ongoing investigation, there have been some state search warrants issued and so forth, and somebody gets charged in the state system. It is entirely possible that the federal agencies, so that could be FBI, DEA, Homeland Security, it's entirely possible that a federal agency has either been involved in the investigation, it's an ongoing investigation, or they get wind of it by talking to their partners on the state side. But the way it works in the federal system is it is discretionary. And so while there's no hard line in the sand about, what gets charged federally and what doesn't, what will happen is, and this is my understanding of it, I was not an assistant United States attorney, but the agents will talk to the assistant United States attorney, they'll take a look at it, and then decide if they want to go forward on it. And this brings up another difference between the federal system and the state system on the criminal side. In the state system, we don't have a grand jury process in Montana. Other states do. Other states do use a grand jury process for charging criminal offenses. We do not in Montana. In the federal system, however, we do. So what happens is if a federal prosecutor is looking at a particular case and decides, I think that this is significant enough for a variety of reasons. Sometimes it will be the amount of drugs. Sometimes it will be, there can be a lot of different factors, I think, that probably go into it. Whether this person is part of a significant distribution conspiracy, things like that. But they don't get to just charge them themselves, generally speaking. There are exceptions, but generally what happens is they have to go to a grand jury. And what a grand jury is, the difference between a grand jury and a trial jury, or a petit jury is what it's called, but we call it a trial jury, is a trial jury is the jury that, like it sounds, is in a trial. They listen to the evidence, or listen to the testimony, they review the evidence. The judge tells them the law that applies to that particular case, depending on what type of case it is. And what the trial jury will do is go back into the jury room and deliberate. And those folks are the people that determine whether to acquit the defendant or convict the defendant. So they're the ones that make that decision. And the burden of proof that has to be satisfied is beyond a reasonable doubt. So those are kind of hallmarks of a trial jury. A grand jury is different. A grand jury does not determine guilt or innocence. That is not the point of a grand jury. A grand jury determines whether there is probable cause to believe, first of all, that a criminal act has occurred, and secondly, that that particular person is the person who committed the criminal act. So the way a grand jury works is a grand jury is selected. We select them once a year. They meet generally once a month, although they don't, there are some breaks during the year for a variety of reasons. And what happens is the prosecutors will present cases to the grand jury, the members of the grand jury, and the grand jury, after they've heard sometimes it's testimony from agents, sometimes witnesses come in and testify, they present evidence. Then the prosecutors leave, the grand jury deliberates, and the grand jury determines whether the United States has proven or established, I should say, probable cause to believe that the criminal act occurred and that particular defendant did it. And if that is the case, what the grand jury will do then is issue an indictment, which is just the charging document. And if you ever have the chance to look at an indictment, it's signed by the foreman or foreperson of the grand jury, and it says a true bill. And the grand jury process is, we brought that over from England with us. And so it is very, very deeply ingrained in jurisprudence, and it really is it's a check, right? Because especially when America, when the settlers came over, one of the things that they wanted to do was make sure that there were checks and balances on the various arms of the government, or the branches, the three branches of the government, but also the folks that work within those branches. And the grand jury is a very powerful check on the government's ability to charge its citizens with criminal conduct. Because there are times, and I don't know how this would work because I've never been on a grand jury, and they are conducted in secrecy, but there are times when the grand jury refuses to return a bill. In other words, they hear the testimony from people, they review the evidence presented to them, and they don't think there is probable cause to go forward on that alleged crime. And so they are a check on the power of the prosecutor. The prosecutor can't just decide him or herself to charge somebody. So that's very important. So it's sort of discretionary. I'm not sure if that fully answered your question. You know, like I said, in my experience, my clients who were charged in the state and then were subsequently indicted on the federal side, almost always, in fact, I don't think I ever had a client who didn't have those state charges dropped. I have heard of it happening. Sometimes what happens is the state court case gets done before the federal prosecutor has decided what to do. So in that situation, they would have completely separate prosecutions for the same conduct. That in my experience, at least in Montana, is pretty rare. Most of the time, the state decides to just forego prosecution once the federal prosecution is underway. Does that answer the question?
I think it answered it for me.
Okay.
Have you, but please, again, I would welcome people to put their questions in the chat function. I do want to go back a little bit to the grand jury function that you mentioned, because I think it's a really interesting aspect and we don't see a lot of it. But you mentioned that comes from the system of England, and so, you know, more powdered wigs and robes.
Right.
But you brought up that it's an important check on the power of the government to bring those charges in the first place.
Mhm.
And I just wanted to reiterate with you, so because you were going through the difference between a jury that hears your trial and says whether you're guilty or innocent, and those are supposed to be of just regular people, right?
Mhm.
And that's also the case with the grand jury. Those are just regular people that are deciding whether the government has established probable cause to bring those charges in the first place.
They are. And so I actually, in the Missoula division, we have grand juries in the Missoula division, the Great Falls division, and the Billings division. We have two other divisions, the Butte division and the Helena division, but we don't run grand juries in those divisions. But I actually impanel the grand jury in the Missoula division. So like I said, we do it once a year. And what happens is you get a summons the same way you would for a jury trial. And it just says, you know, show up at the courthouse at this particular time. You have been selected to be a potential grand juror. And everybody comes in. The grand jury selection is different. You know, if you have, and I know, I'm sure I wouldn't be the first to tell you, but let me be somebody to tell you that, you know, the Law and Order and the court procedurals that you see on TV are fairly wildly not accurate. I mean, they're dramatic, right? They're TV shows. So, you know, there's just a lot of drama to that does not happen in a regular courtroom and that would never really happen in a regular courtroom. But I'm sure if you've seen any of those shows, you know, you get the gist of what a trial juror does. And so when a trial jury is selected, you know, the judge will ask some questions and the prosecutor will ask some questions, or the plaintiff, if you are, you know, in a civil case, and the defendant's lawyer will get to ask questions. We call that voir dire. That's the questioning of the jurors to make sure they can be fair and impartial. And in a trial jury setting, there's a couple voices, right? There's the plaintiff or the prosecutor and the defendant. In the grand jury, that's not the case. The grand jury selection, it's just the United States attorney. There is no other participant, and the court. There's no other participant. And so what happens is all these people come in. We select folks, we select a number of those folks. They sit in the jury box in some chairs that we have in the front. And then we go through and ask them questions. I ask most of them, and they really are. In fact, in the grand jury selection, I ask all of them, unless there's something that comes up that the U.S. attorney feels we might need some further follow-up on. And it really is things like, where are you from? What do you do for a living? Have you been a juror before? How was that experience? Have you had any interaction with the criminal justice system on any level, whether it's been a juror, a defendant, a family member who's been involved? Has anything about that experience made it difficult for you, or would make it difficult for you to be a grand juror? And I just sort of engage folks in a dialogue and find out more about their background and so forth. Once we're done with the questioning, I meet with the U.S. attorney, and unless there's a reason that somebody can't sit on that grand jury, and usually we've already figured that out, we just select them. We talk about who would be the most appropriate foreperson and assistant foreperson, and then those folks are the grand jury for the next year. So that's a real key distinction in terms of how they're selected, but the types of people that are selected are just the same. They are just folks who are either registered voters or licensed drivers within whichever division we're picking a grand jury for. The other difference between, and I would tell you, whenever we impanel a grand jury and I kind of talk about what the next year might look like, everybody's face is full of panic, because it sounds like, oh my gosh, that's a full year of jury duty, which obviously would be a lot. But what really happens is I think we meet 8 times a year, or they meet 8 times a year. Maybe it's 9. Every year is a little bit different. We take, the months around the holidays off and so forth. And it usually is about a half a day. Sometimes it's a little bit longer depending on what's going on. So I've been doing this for 5 years, and I had to preside over impaneling a grand jury like on the second week that I was on this job. I had never seen it happen before because I wasn't a U.S. attorney. I had no idea how it worked. So, I mean, talk about green, my gosh. But it was really kind of fun talking to the people over the next year, because I meet with them every month when they come back and bring the indictments back. I meet with them, I take the indictments, I sign the order that issues summons and subpoenas and arrest warrants and things like that. And every single person who has talked to me about it has thoroughly enjoyed the process. And I think because it's just such a great window into the workings of our government that very few people get to see. Because, also people forget the judiciary is part of the government, and being on a jury or a grand jury is such an amazing service that we need to perform our function. But also, I think it's just an amazing opportunity for everybody to participate in the governance of our own citizenry, but also to see really how it works. And I love doing that part of it. So if any of you ever get selected, I know it sounds like a lot, but it actually is a very rewarding experience. But that's the grand jury.
I no, I'm glad that people actually do, find it a really positive experience.
Yeah.
One of the issues I guess that we've had, in the first judicial district, and probably in Missoula too, is, finding jurors that are willing to sit on whether it's for the trial jury or a grand jury, but is trying to find people. Do you have any good stories of what's the most creative excuse you've ever heard for not wanting to be on a jury?
So since I can't do federal criminal trials, I can only do federal civil trials. And I've really only done 2, because most cases get resolved by mediations. That's another thing that I should have said. One of the things that federal magistrates do, in fact, we do them all the time, is mediations or settlement conferences for federal cases. I probably do, oh gosh, I don't know, anywhere between 4 to 8 of them a month. And so do the other magistrate judges. So most civil cases don't go to trial. Most civil cases get resolved either by mediations or getting resolved by motions. But on the grand jury, I think we haven't had, I've certainly heard stories about how difficult it is to get people in the state system to show up for jury duty. And we have that a little bit, but trying to think of how to say this. Well, if somebody doesn't show up for jury duty, they get a stern letter saying, you need to tell me why. And if they don't respond, then they get a visit from the United States Marshal, and the United States Marshal brings them to court. I mean, they have to they can send a letter, generally explain what happened. If it's satisfactory, we write back and say, don't do that again, or, you should have let us know ahead of time. You don't just not show up. Then there's a show cause hearing that they can show up to voluntarily. If they don't show up to the show cause hearing, they're most likely going to get arrested and brought to court. And released, I mean, they're not going to be spending time in jail, but they would be certainly required to explain their position to the judge, which isn't a very fun position to be in. And the grand jury, we haven't had a lot of problems with people not showing up. Sometimes people will call ahead, for a variety of reasons they can't make it. They've moved out of state. They're going to be on previously scheduled vacation, things like that. Most of the time, the issues that come up for people with jury duty it's a hardship for them for their work, or they're stay-at-home moms who don't have childcare other than themselves and, wouldn't be able to do it for that reason. Sometimes people have health issues that make it difficult. And I just listen to them and talk to them and see if we can't figure out a way that we can either make it possible or determine that, yeah, you're right, you really probably can't be on this jury. But I personally haven't had a lot of experience with people coming up with, sort of outlandish reasons why they can't sit on the jury. And I will tell you, I will say though, that like, even the people where you can tell they're doing it begrudgingly, when they're done, they're like, I'm really glad I did that. Like, I really see the value of it now. And just the way I think about it is, if we were ever in a situation where you're in a lawsuit and you want someone to, listen to what you have to say and determine what the issues are and make a decision about, what the eventual outcome should be, it should be jurors. I mean, we have the jury system for a reason. And I think that there is, I firmly believe in that process. People don't always agree with jury verdicts, and I understand that, but it doesn't mean that our system is wrong. And so I feel very strongly about jury service. And, once you're a lawyer, I'm sure, as you know, you're never allowed on a jury. People kick lawyers off prospective jury pools all the time. Although I actually got to sit on one when I was an attorney, and it was fascinating, and I very much enjoyed the process. But yeah, I feel pretty strongly about the system, and it is great. So yeah. I don't know. Are there any other questions?
I'm not seeing any other listed questions on there, but I'm also glad that Tina Fey from 30 Rock never showed up dressed up as Princess Leia in your courtroom.
Yeah, no, never
Good.
happened. Yeah. Well, maybe I can, oh, is there a question? I think I got a little pop up there.
Yeah.
Oh,
So somebody, yeah, it's a great question. Why,
yeah,
because you mentioned once you become a lawyer, you're never going
yeah,
to be on a jury. Why is that?
yeah. So you absolutely can be on a jury. What happens is the parties mostly don't want you on a jury. And I think there's a variety of reasons for that. I mean, sometimes it's because they are worried or concerned that as a lawyer, you might, you know, have a heavy hand in the jury deliberations, because especially if you do trial work. I mean, not every lawyer does trial work, there are lawyers that do estates and probate that never, never are inside the courtroom. But generally speaking, if the thought process is, well, a lawyer is going to know more about how it works, then there's a potential that they would, be too heavy-handed in the jury deliberations and really steer it just towards them, kind of dominate it. The other issue is they might know a lot about that particular area of law and might have a much more jaundiced view or a much more, expansive view of what the facts or the interaction or interplay between the facts and the law, and they might not like that as well. I was on, so the case that I was on was a case in justice court, and it was a DUI. The judge knew I was a lawyer. The defense attorney knew I was a lawyer. I think the prosecutor knew I was a lawyer, although it was a student practitioner, but there was an actual county attorney there as well. But none of them bumped me, and I was shocked. And I didn't tell anybody on the jury that I was a lawyer, and they didn't even ask me about it, which is also unusual, because usually what happens is during the voir dire process, they'll say, "Hey, Ms. DeSoto, you're an attorney, so tell me about that burden of proof," because they want to distinguish between, a criminal case and a civil case, which have different burdens of proof. Nobody did that at all. So literally nobody on the jury even knew I was an attorney, which is kind of nice, because I just sat there and, I piped up when I wanted to, but I never said, "Hey, well, this is how the law works," or anything like that. And I think it was, they found out afterwards and they were like, "Why didn't you tell us?" So it was kind of funny, but, yeah, I think, and then the other time I was on a jury panel in federal court, but I got bumped, and I'm not sure who bumped me, but I was not allowed to be on that jury either. But they absolutely can. It's just in practice, it's very rare for a lawyer to be on a jury.
Yeah, I've definitely experienced that too. We do have another question. Well, we have a general comment from someone that they totally believe in jury service. It's a really
Oh.
important thing. Just totally agree with. And then we have a question about why did you want to be a judge, and maybe kind of sidebarring onto that. What's your favorite and least favorite part about being on the bench?
Sure. Well, so I am not somebody who sprung out of the womb wanting to be a lawyer, even. I wanted to be an English teacher, and I went to undergrad, got a degree in English and Latin, went to graduate school, uh, taught abroad, came back, and then was sort of at loose ends. And I ended up getting a job as a legal secretary for a couple of guys here in Missoula, and fell into that just because I could type really fast and I had a writing background. And so they're like, "All right." Um, and then when I started working for them, I was like, "I kind of like this. I think maybe I could do this." And so there was nothing more deliberate about me going to law school. And so you can guess then that it wasn't like I wanted to be a judge ever. I mean, that really wasn't on my radar. I was in court a lot, had a trial practice, and I was in federal court primarily. And so, I was really familiar with the federal court system. And one day I was just thinking about, I had sort of an opportunity to maybe take a different career path. And I was driving my daughter to ballet class. And I was thinking, what do I want my life to look like in 4 or 5 years? How do I see that? How do I see that playing out? And it just popped into my head. I was like, I think when Judge Lynch retires, maybe I'd want to do that. And again, nothing more deliberate than that. And then eventually when, the judge, announced his retirement, I threw my hat in the ring and then went through the process of applying and getting selected. Yeah, the pay probably in the private practice is probably different. I mean, it can be, it depends on what you do. There are every job has upsides and downsides. And, whenever students ask me, law students ask me, how should I decide what job I want to take and so forth, I just say there's no such thing as a free lunch. And with a big paycheck comes a big expectation of hours and the time that you will devote to the job and so forth. I loved being a lawyer. I didn't love it every day, and I didn't love it all day every day. But overall, it was intellectually stimulating. I got to meet some amazing people. I got to help a lot of people, and I really thoroughly enjoyed it. But it was a lot. It was a lot of time. It was a lot of stress. And so for me, there is stress involved in being a judge. The way I look at it is there's a lot of pressure to make the right decision. And sometimes it's apparent what the right decision is. Most of the time it's not. Or there's a lot of, there's a variety. There could be a lot of different right decisions. And your job as the judge is to decide what is the most right decision based on the particular facts of that case and the law that applies to that case. That can be incredibly challenging. I am acutely aware all the time of how important every case is to every party. I mean, on both the criminal and civil side, people's lives, sometimes it's liberty on the criminal side, sometimes it's livelihood or, damages or, depending on what the civil case is. But I'm acutely aware at all times that these cases are the ultimate importance to the parties involved. And I owe it to them to do the best I can to make the right decision. And that can be super stressful because I try very hard, but I'm not always right. That's why we have appellate courts. So I feel that stress. But the stress of being a judge is different than the stress, I think, of private practice, where, as a judge, I'm in a lot more control of my surroundings. I'm in a lot more control of my schedule. As a lawyer, and Anna can testify to this, as a lawyer, you have to follow the schedule of all of your cases, and you don't have one case, you have a lot of cases. Those schedules can be conflicting and it can be really stressful. There was a lot of travel involved, for me at least, and and that's hard as an attorney. I think, I look at this as a service. I think being a lawyer is a service industry as well, but a judge definitely is a service industry. We are here to serve the public. Um, and so I enjoy that very much. It's a great way to be able to give back. And it's also intellectually incredibly stimulating because, as a lawyer, I had kind of a general practice, but there were certain things that I practiced more, certain areas of the law that I did more. Well, as a judge, I literally have to handle everything that crosses my desk. So environmental cases, I never worked on an environmental case as a lawyer. I mean, that was not my wheelhouse. A patent case, never did a patent case as a lawyer. So it can be intimidating at first, like, wow, that's a whole area of the law that I literally know nothing about. But it's also really fun because I get to just jump into it, and really immerse myself in the law and the facts, and then have maybe an oral argument on a motion where I get to say to the attorneys, tell me why this is this way, or what do you think about that issue? And it's very fun and engaging, and I very much enjoy that. So yeah, I mean, I think that yeah, I mean, depending on exactly what type of practice you have, it could pay less than a private practice position, but there are definite benefits to it as well.
So I mean, I can definitely appreciate that you probably get a lot of, there's a different kind of stress is what you're describing than from being a lawyer.
Yeah,
But have you, and you deal with a criminal docket every day, have you ever felt unsafe or in danger as a
no,
federal judge?
I never have. Um, you know, and maybe that's because I did criminal defense when I was in practice. So I personally have never felt in danger. I mean, when you're working with folks on the criminal side, you're seeing them on their worst day. They're having a very bad day. And I used to say this to my clients, you're going to have a bad day on the day we go in to change your plea. You're going to have an even worse day on the day of your sentencing. And you just have to know that every day forward is a day that you're closer to being home with your family. So appreciate it that way. Think of it that way. And maybe that will help. But, when I feel the stress on the criminal side when I handle detention hearings, or when I'm considering whether somebody should be released uh, or detained. We have a statute, it's the Bail Reform Act, and that is the statute that governs detention decisions in the federal system. And in Montana, at least in the federal system, we don't use bail at all. So you are either released on conditions or you're not released. And the Bail Reform Act carries with it a presumption of release. And but these decisions don't occur in a vacuum, and so what will happen is I'll get a fairly detailed bond report that will give me a criminal history, some background information, and then I have to make decisions about whether somebody, and the things that we look at are flight risk and danger to the community. Danger to the community is more expansive than it sounds. It's not just, oh, do I think this person is violent? It is there a danger that this person will continue the criminal conduct that got them in front of me in the first place. But obviously safety of the community is also a paramount concern. And, those are hard decisions to make, because I'm also aware that, folks have families, folks have jobs. And when you're in jail, you're going to, potentially lose your housing. You're going to potentially lose your job. If you shouldn't be in jail, I need to get you back out. If you should be in jail, that's appropriate and that's fine. And so there's an analysis that I go through and so forth. But it's, sometimes it's easy. Sometimes it's a clear, yeah, you should be out, or clear, oh my gosh, you should absolutely stay in. Most of the time it's not. And so it does weigh heavily on my mind. I need to make sure I'm making the right decision given all the factors that I have to weigh at the time. But ultimately, my paramount concern is safety to the community, and I need to make sure that there won't be a bad outcome if I release somebody. So that is one big stressor to me. And I've lost some sleep over some of those decisions for sure.
I bet those are not easy decisions. But I guess, just to follow up on that question, and I don't know if this is what the asker intended to ask, but I guess in the day-to-day operations of the courthouse, you've never felt unsafe, or is there a pretty robust security system at the courthouse that, you feel pretty confident in?
Yes, we have a very robust security system here. That is, so to come into the federal courthouse, we have court security officers. We have a metal detector that you have to go through first. You have to give your name. You have to provide identification. All of our chamber, we're locked off. When we're in court on criminal matters, there are always U.S. Marshals who bring in the defendants. We have court security in the courtroom as well. And they take it very, I would say that the federal judiciary takes security very seriously. There was a situation not long after I got on the bench where a federal judge in New Jersey, her son and husband were shot. Somebody came to their home, found her home address, came to her home, and shot and killed her son and injured her husband. And that was, as you can imagine, a huge shock. Even before that, we had pretty good security, but it was a very significant shock. And, there's just no room for that, in my opinion. Disagree with decisions and so forth. But I don't think violence against the judiciary is ever an answer or a good thing. But so we do take it very seriously, and our physical buildings are very secure. And I appreciate that. I appreciate the fact that the CSOs and the marshals take that security very, very seriously.
Well, we are coming at pretty close to the end of our time, but we did have some questions that just came in. So the first one should be pretty quick for you, but can the public attend federal hearings and/or trials?
Absolutely. Yep. Everything is public. Juvenile, if you were over in Billings or Great Falls where they do juvenile proceedings, those are not public. Those are closed. But other than that, and there are some limited other criminal, some competency hearings. But other than that, yeah, they're all presumptively public. And you can get on the website, the federal court website, and you can see the calendar, like for hearings or appearances. They're all on our public website. So if you ever wanted to just go down and see federal court in action, you're certainly able to do that.
Give the lawyers who are participating a bit of an audience. Sometimes we appreciate it.
Yeah.
And then one last question. This one is a little bit more detailed. So I guess this is up to you how you want to frame a response to this, but what are the conditions for parole? Is there certain percentages of your sentence that you have to serve before you're eligible, or is it up to the judge?
So we don't actually have parole in the federal system. It is a key distinction between state and federal. In most state systems, you might be eligible for parole, which is basically being eligible to be considered for release earlier than you're scheduled to be. We do not use that in the federal system. It does not exist. So the way it works is if you are sentenced, and I always tell people this in plea hearings, and I told my clients this when I was an attorney, in the federal system, you have to presume that the sentence that you get is actually the sentence that you serve. So if you are within the Bureau of Prisons, that's the federal prisons system, you can accrue good time, and they take those days off. It's 54 days a year, I believe. And so you can accrue that good time and they will take those days off. Then there's programming within the BOP that you may qualify for. The judge can recommend placement in some of that programming. The judge cannot require it. So that really the BOP determines if you are eligible for that. Some of that programming has the effect of taking additional time off. But other than those limited circumstances, the good time and any of the days you may get for certain programming events, there is no get out early. Now, generally speaking, what happens is, you're going to get released to a halfway house. So there's like 6 months, I think, generally, although that may differ, where you're technically in BOP custody still, but you're in a halfway house or a pre-release in the jurisdiction you're going to be released to. But if you get a federal sentence, there's no possibility of parole. It just doesn't exist in our system. So that's a good question.
Yeah, we had some great questions, and so
Yeah.
thank you guys for participating, because those are, I know the judge specifically wanted it to be a little bit more interactive, and we got a lot of questions about a lot of different stuff. So thank you. I think that is, oh, I say that and one more popped up. That's just general advice, general comment. So it's helpful and informative. And if anybody hasn't already watched the show Jury Duty on Amazon Prime, check it out. I will attest to that one. That one's pretty funny.
Yeah, my daughter watched it and said it was hilarious, so I need to do that.
Definitely you get a good chuckle out of it. But I think we're at the end of our time here. Thanks for hanging in, and a big thank you to Judge DeSoto for giving her time to do this. Like I said, it's not very often that we get to ask these types of questions of judges, so thank you again for your time. And I hope everybody that's tuning in tonight will continue to show up for the other Citizens Law School topics, because there's some really other interesting things that we're going to be covering as well. So thanks, you guys. Have a good night, and thanks for tuning in.
Thank you, everybody. I appreciate it. Take care.